Hello, and welcome to Divorces in North Carolina, Sandra Dinkins. Today, we will answer some pressing questions about the child collection process in North Carolina. Navigating through child support issues can be challenging and complex. That's why we've collated 8 of the most commonly asked questions to help you understand and navigate the system better. This video is designed to provide you with clear, concise answers to these questions, shedding light on the process, your rights, responsibilities, and the various steps involved. We'll be referring to the guidelines and processes established by the North Carolina Department of Health and Human Services, the governing body responsible for child support enforcement in the state. From what to do when court-ordered child support isn't being paid, to understanding the fees associated with child support services, to knowing your rights and responsibilities as a custodial parent, we've got you covered. So let's dive into our first question. First up, my ex-husband just stopped paying his court-ordered child support. How can I get help to get him to pay child support? When a non-custodial parent stops meeting their court-ordered child support obligations, it can create a significant financial burden for the custodial parent. But don't worry, there are steps you can take to address this issue and ensure the financial support for your child is maintained. The first and most crucial step is to contact your local child support agency. In North Carolina, this is the Department of Health and Human Services, or NCDHHS. The agency has the authority to enforce child support orders and can help you navigate the process. You can reach out to them by phone or visit their website to file a formal complaint. This complaint will get the ball rolling, and the agency will start the process of enforcing the child support order. It's essential to provide as much information as possible when filing the complaint. This includes details about the non-custodial parent, like their last known address, place of employment, and any other relevant information that could aid in the enforcement of the order. Once the complaint is filed, the agency will take numerous steps to enforce the order. This may include income withholding, where the child support payments are directly deducted from the non-custodial parent's wages, interception of federal and state tax refunds, or even suspension of the non-custodial parent's driver's license. Remember, each case is unique, and the enforcement methods used will depend on the specifics of your situation. However, the goal remains the same: ensuring the financial support necessary for the well-being of your child is provided. While these steps can be a bit overwhelming, remember that you are not alone. The NCDHHS is there to support you and ensure that your child receives the financial support they are entitled to. For more detailed steps and support, you can visit the NCDHHS website. Our second question is, what documents do I need to apply to child support to get the help that I need? When applying for child support services, you'll need to gather a few essential documents. These are crucial for the Child Support Office to accurately process your application and ensure that all the necessary information is at hand. First and foremost, you'll need proof of your identity. This could be any government-issued ID, such as a driver's license, passport, or state-issued identification card. This helps the office verify who you are and ensure that the right person is applying for support. Next, you'll need to provide proof of income. This is crucial because it helps determine the amount of child support that can be ordered if you don't have a court order. Proof of income can be in the form of recent pay stubs, tax returns, or even a letter from your employer stating your income. If you're unemployed, you'll need to provide documentation to that effect as well. Additionally, you'll need to provide your child's birth certificate. This establishes the legal relationship between you and your child, and it's an essential document for the child support process. If you don't have a copy of the birth certificate, you can usually obtain one from the Vital Records Office in the state where your child was born. If you're divorced, you'll also need a copy of the divorce decree or separation agreement. These documents contain important information about any existing child support arrangements and can clarify the terms of your separation. Lastly, if there are any existing child support orders, be sure to bring those along too. This could be from a court or another state's child support agency. These documents are the basic requirements, but depending on your situation, additional documents might be needed. Always check with your local child support office if you're unsure about what to bring. Make sure you have all necessary documents ready before applying. It's always better to be over-prepared when dealing with matters as important as child support. Next up, other than the $25 application fee, what other fees may I be required to pay for services at the Child Support Office? Now, while the standard application fee is $25, there may be additional costs to consider when utilizing the services of the Child Support Office. The first of these could be court costs. If your case ends up in court, you may need to pay for the court's time and resources, though this isn't always the case. It's worth noting that these costs can vary widely depending on the specifics of your case and the court's decision. Yet another fee you might encounter is related to DNA testing. If paternity needs to be established and a DNA test is required, you may be responsible for covering this expense. However, it's crucial to remember that many times, these costs can be recouped from the other parent, should they be found to be the biological father. Also, in some cases, there may be fees associated with the enforcement of child support orders. These could include costs for wage garnishment or seizing assets. However, these enforcement fees aren't always the responsibility of the custodial parent and can sometimes be passed on to the non-custodial parent. Lastly, let's talk about the possible fees for modifying a child support order. If circumstances change and you need to modify the existing child support order, there may be associated fees. But again, these fees can vary greatly based on the specifics of your case and your location. In conclusion, while the application fee for child support services is a flat $25, there are several potential additional costs to be aware of. These can include court costs, DNA testing fees, enforcement fees, and modification fees. However, it's important to keep in mind that these costs can vary greatly and may not always apply. Remember, these fees vary and may not apply to everyone. Now, we move on to, as a custodial parent applying for help in collecting child support, what are my rights and responsibilities? As the custodial parent, you have a set of rights that are designed to ensure the well-being of your child. One of the most fundamental is the right to receive timely and full child support payments. This right is protected by law, and the child support offices are there to help enforce it. You also have the right to request a review of the child support order if there are significant changes in circumstances. For instance, if the non-custodial parent gets a substantial raise, or if your child's needs significantly increase, you have the right to request a review and potential adjustment of the child support amount. But it's not just about rights. With these rights come responsibilities. One of the most important responsibilities you have is to provide accurate and up-to-date information. This includes information about your income, the non-custodial parent's whereabouts, and any changes in your child's needs. This information is crucial in making sure the child support order is fair and serves the best interest of your child. Another key responsibility is to comply with all court orders and child support program rules. This means you'll need to respond to requests from the Child Support Office promptly and attend all court or administrative proceedings. You also have a responsibility to notify the Child Support Office of any changes in circumstances that could affect the child support order. This could include changes in your income, your child's needs, or the non-custodial parent's ability to pay. And finally, you have a responsibility to use the child support payments for the care and well-being of your child. This can include essentials like food and clothing, as well as expenses related to education, healthcare, and other aspects of your child's development. Every situation is unique, and the child support process can be complex. But understanding your rights and responsibilities can make it a little easier. By working closely with the Child Support Office and being proactive in providing information and complying with orders, you can help ensure that your child receives the support they need. Knowing your rights and responsibilities can help you navigate this process smoothly. Our sixth question is, do I need to establish paternity if I have a court order and if I was previously married to my child's father? This is an important aspect to consider in the realm of child support. Establishing paternity means legally determining the father of a child. When parents are married at the time of a child's birth, the law generally assumes the husband is the father. However, in cases of divorce or separation, establishing paternity may still be relevant. Why is it so crucial? Establishing paternity is not merely a matter of assigning responsibility. It is about ensuring the rights and benefits of the child. This includes rights to child support, inheritance, access to the father's medical and life insurance benefits, and Social Security. Additionally, it can provide a sense of identity and connection to the child. But you might wonder, I was married and we have a court order. Isn't that enough? In many cases, yes. If the father's name is on the birth certificate and there was a legal marriage, this can serve as official recognition of paternity. However, circumstances vary, and sometimes additional proof of paternity may be required. For example, If there were questions about the validity of the marriage, or if the father's name is not on the birth certificate, you might need to take additional steps to establish paternity. This could involve genetic testing or a court proceeding. In some cases, even with a previous marriage, a declaration of paternity might still be necessary to remove any doubts and ensure the child's legal rights. Remember, each situation is unique. If you're unsure about the need to establish paternity in your case, it's always best to consult with a legal professional or your local child support office. They can provide guidance based on your specific circumstances. In conclusion, establishing paternity is an important step in ensuring your child's rights. It's not just about securing child support, but about safeguarding the overall well-being of your child. We now discuss, what if I don't know where my ex-husband lives? Let's imagine you're in a situation where the non-custodial parent of your child has moved and you're unsure of their current whereabouts. This can indeed present a challenge in the process of child support collection. However, it's important to know that the North Carolina Department of Health and Human Services, or NCDHHS, is equipped to handle such situations, and they have a range of resources at their disposal to locate non-custodial parents. The NCDHHS can utilize both state and federal resources to track down the non-custodial parent. At the state level, the department can access information from multiple sources like utility companies, law enforcement agencies, and even the Department of Motor Vehicles. This extensive network allows the NCDHS to gather information that might lead to the whereabouts of the non-custodial parent. On a federal level, the NCDHS can tap into resources such as the Federal Parent Locator Service. This service can access information from federal databases, including those of the Internal Revenue Service and the Social Security Administration. It's a powerful tool that can greatly assist in locating a non-custodial parent, even if they have moved out of state. While it's true that these processes may take some time, it's crucial to remember that the NCDHHS is committed to ensuring the well-being of your child. Their goal is to ensure that non-custodial parents fulfill their obligations, regardless of where they might be located. So, if you're facing the question, what if I don't know where my ex-husband lives? Don't panic. The NCDHS has a deep well of resources to draw upon in order to help locate non-custodial parents. Rest assured, the NCDHS has resources to help locate non-custodial parents. Finally, how can I help the Child Support Office to locate my ex-husband? The answer is quite simple, by providing as much information as possible. The North Carolina Department of Health and Human Services, or NCDHS, is dedicated to supporting child and family well-being, but they can't do it alone. They need your help. Every bit of information you provide about the non-custodial parent can make a significant difference. Do you know their current or last known address, their place of employment, or perhaps the name of their new spouse? What about their social security number, or details of any property they own? Any of this information can be incredibly helpful. If you are getting value from this video, please subscribe. Remember, the more information you can provide, the better equipped the NCDHHS will be to locate the non-custodial parent. This isn't about playing detective. It's about ensuring that your child receives the support they are entitled to. Your cooperation can significantly speed up the process. Well, that concludes our Q&A session on the child collection process in North Carolina. Let's quickly recap what we've discussed. If your ex-spouse has stopped paying court-ordered child support, you can seek assistance through the North Carolina Department of Health and Human Services Child Support Collection Department. They're equipped to enforce the payment of child support. When applying for help, you'll need specific documents such as your ID, your child's birth certificate, and details of your financial situation. Apart from the $25 application fee, there might be other costs involved, but these depend on the specific services you require. As a custodial parent seeking help, you have certain rights, like the right to request a review of the child support order, and responsibilities, such as cooperating with the child support services. Even if you were previously married to your child's father, establishing paternity can be essential in some cases, particularly if the court order doesn't specify paternity. If you don't know where your ex-spouse lives, child support services can use various resources to locate them. And finally, you can assist in this process by providing as much information as possible about your ex-spouse to help locate them. For more detailed information on these topics and more, do visit the NCDHHS website. They provide a wealth of resources and support for parents going through this process. Thank you for joining me today. Remember, you are not alone in this process, and there are resources available to help you.